Welcome to Foundations of a Zen Business Module 1, Contract Foundations. In this module, we're going to dive deep into contract foundations, types of contracts you might need, best practices, and tips for using contracts, and what to do in a contractual dispute. All right, let's begin with Contracts 101. We're here to simplify the complex nature of legal agreements, ensuring you have a clear understanding and confidence when entering into contractual relationships. I know, contracts sound a bit daunting and even boring at sometimes, but honestly, there is nothing more exciting than contracts. They build your business, set your foundations and boundaries, create clear communication, and most importantly, make you truly think about your business. A signed contract is a binding agreement. When writing or signing contracts, you want to make sure that you have a complete understanding of what is included. It's important to not just have quality terms in a contract, but also to understand what those terms require of you. Please remember that contracts are not one size fits all. They need to be independently adjusted to your business, and the only way to do that is to understand the terms fully or hire an attorney. And please do not copy and paste contracts from Google. I've seen some wonky contracts out there that are completely unrelated to what the business is doing. Same thing goes for drafting contracts with ChatGPT. I use ChatGPT for a lot of things like ideas or social media, and trust me when I say that a contract written by ChatGPT will not be suitable for your needs. They come with a lot of mistakes and legal inaccuracies. The technology is just not there yet. And if you don't understand legalese, lawyer language, you won't be able to tell if a term is correct or not, or even if it's legal to have. So hire a lawyer or purchase a lawyer-drafted contract template. Contracts are more than just legal necessities. First of all, they set boundaries and create a structured framework from the get-go, ensuring everyone knows their rights and responsibilities. They prevent conflict and misunderstandings by outlining terms and conditions as a reliable reference. Having a good written agreement actually reduces and prevents disputes. And lastly, they provide legal protection and risk management. Think of contracts as a proactive risk management tool as they identify and address potential issues upfront, ensuring a smoother relationship. Bottom line is, they're important, and you should always have them. Don't ever be scared to send a contract to anyone or negotiate contract terms. So let's go through some of the basics. Anatomy of a valid contract. A contract needs to include a few aspects in order for it to be valid. First of all, there must be mutual assent, which basically means that both parties agree to the terms of the contract and there is an intention to commit to the relationship. For example, a graphic designer and client agree on the scope of terms for a design project. 2, there must be a valid offer and acceptance. The key term here is valid. A counteroffer does not count as an acceptance, or you can't offer something that you don't own. For example, you cannot sell a car that you don't own. 3, adequate consideration. Every contract requires an exchange of value, aka consideration. Usually this is monetary compensation. You offer a service and your client pays you money. But consideration doesn't necessarily have to be monetary. It could also be an exchange of services. For example, I'll make you a website and in exchange, you will do my branding. But there needs to be some sort of exchange of value. Capacity. This is the legal ability of a party to enter into a contract. They must be of legal age, sound mind, and not restricted by legal constraints. For example, if they have a non-compete. And lastly, legality. This means that the contract should be ethical and within the bounds of the law. If you've ever heard of someone signing a napkin and it being a legal agreement, this is completely true, and there have been many cases around it. If the napkin contract contains all of these requirements, it is a valid contract. I know this is a bit of a breakdown, and you might not need all of this information, but understanding the basics will set you up for success when actually reading contracts. So how can contracts protect you and your business? Let's go through a few ways that they can actually really help you. First of all, contracts include clauses that limit your liability. This means that if someone sues you, you can limit the amount of money or damages owed. For example, you created a logo that accidentally looks very similar to Nike's logo and give it to your client. Your client gets sued by Nike and owes them a lot of money. The client then sues you and says, hey, you created a logo that has already been trademarked and I'm being sued, so you owe me all of the money that Nike's demanding from me. A simple clause that states that it's up to your client to check if the logo has been trademarked before will prevent this lawsuit from going through, which means that you won't owe the client any money. That is limiting liability. Secondly, contracts provide a variety of remedies. This is basically your legal safety net. Remedies are what happens when issues occur and how they can be rectified. Such remedies include monetary damages, specific performance, and injunctive relief. For example, your client goes to you on payment. You can have a clause in your contract that states you charge monthly interest and then take your client to collections or arbitration for non-payment. Now, contracts also prevent litigation, aka going to court. This saves you time and money. We watch a lot of legal TV shows where all they show is lawyers in court all day, every day, with very dramatic battles. Actually, as lawyers, our first job is to absolutely dissuade you from going to court. Court is extremely expensive, and we're there to care about our clients and do not want them to go and bankrupt themselves with frivolous proceedings. You can have a clause in your contract that states all disputes will first go through negotiation and then arbitration. Negotiation is pretty self explanatory, but arbitration basically involves a neutral third party, usually a judge, who helps resolve the dispute. It's much faster and much cheaper than going to court. Those TV shows will make you believe that going to court is instantaneous, but actually it takes months or even years depending on the complexity of the case. Lastly, contracts prevent international disputes. If you've ever seen a contract, you'll notice that general section at the very bottom with a bunch of short clauses that might not make a lot of sense to you, but they are all important. Do not delete them. One of those clauses specify the location where any dispute will be resolved. By writing your state or province or country, you can ensure that any legal proceedings occur under familiar laws and nearby. For example, a freelance writer in New York includes a clause ensuring that any legal dispute with clients will be resolved in New York, preventing potential travel to other states or even countries. Now, this is just to name a few aspects that contracts can help you with and save you a ton of money when things go wrong. Next, we're going to dive into different types of contracts and which ones you need as a business owner or freelancer.